Hello everyone. In March 2023, Congress leader Rahul Gandhi was disqualified from Lok Sabha. In this video, we will be discussing about this with respect to exam point of view. This is important topic for Indian polity. We will be discussing about the grounds on which there could be the disqualification of member of parliament. Let's get started with that. So, Rahul Gandhi had made a remark about Modi's surname during 2019 elections. So the case was filed against him under Indian Penal Code section 499 and 500. So 499 elaborates on defamation could be through words either which are spoken or intended to be read through signs as well as visible representations. And Section 500 of Indian Penal Code stipulates imprisonment of up to 2 years with or without fine for someone held guilty of criminal defamation. So he was held guilty and sentenced to 2 years in jail by Surat court in the defamation case. So, talking about the defamation law in India, Article 19 of Indian Constitution grants freedom of speech to its citizen. However, Article 19(2) has imposed certain reasonable exemptions to this freedom, such as contempt of court, defamation, as well as incitement to an offense. It is also often argued that defamation laws are violation of fundamental rights that are guaranteed under Article 19 of Indian Constitution. In India, the member of parliament can be disqualified on various grounds. We will be discussing about those grounds. First is on the grounds of defection. So, a member of parliament can be disqualified if they voluntarily give up the membership of the political party on whose ticket they were elected. This is called defection. So, let's say an MP has been elected, and at that particular time he was in party A. But later, if he decides to join another party, let's say B, he can be disqualified under anti-defection law. Now, where is this anti-defection law present? This anti-defection law is in the 10th schedule of Indian Constitution. So this anti-defection law was passed by the Parliament in 1985 through 52nd Amendment, and this law is applicable to the member of Parliament as well as to the member of Legislative Assembly as well. Now, another disqualification could be on holding an office of profit. So, if an MP holds an office of profit under the government of India or any state government, they can be disqualified. Why is this present? To prevent any conflict of interest between the responsibilities of an MP and the other government rules. So, if you look at Parliament Prevention of Disqualification Act of 1959, It is this particular law which prevents any MP from holding an office of profit. So this article finds its power from Article 102 1A of Indian Constitution. So the third disqualification could be due to absence. So an MP can lose their seat if they remain absent from the parliament for more than 60 days without prior permission. This is called disqualification due to absence. While there is no any specific rule regarding the number of days the MP should be present, but if an MP is absent from the house without any prior permission for 60 days or more, their seat can be declared vacant by the Speaker of Lok Sabha or the Chairman of Rajya Sabha. So Article 101 of Indian Constitution has provision to disqualify an MP on grounds of being absent for 60 days or more without any prior permission. So the disqualification could also be on the grounds of conviction. So an MP can be disqualified if they are convicted of an offense and sentenced to imprisonment for a period of 2 years or more. This provision is given in the Representation of People's Act 1951. So Section 8 of the Representation of People's Act 1951 provides that a person who is convicted of an offense and sentenced to imprisonment for 2 or more years is disqualified from being a member of parliament as well as voting in any election from the day of conviction for a period of 6 years from the date of release from the prison. Again, the Representation of People's Act 1951 is a law that is made by Indian Parliament which finds its core from Article 102 1E of Indian Constitution. Now let's look into why, and we looked into the different grounds on which a member of parliament can be disqualified. So now let's look into how did Rahul Gandhi lose his MP status. So the Lok Sabha Secretariat issued a notification, as you can see over here, on Friday, that is 24th March 2023, which states Rahul Gandhi's membership of parliament has been cancelled. And on what grounds it is being done? It is because of his conviction and sentencing by a local court in Surat on Thursday, 23rd March 2023. So this notification explains that Rahul Gandhi is disqualified from being a member of Lok Sabha from date of conviction as per the provisions of Article 1021E of Constitution of India, along with the Section 8 of Representation of People Act 1951. The lawmakers do get carried away during the election and they make derogatory statements against each other, which should be avoided as far as possible. So in this video, we looked into the grounds on which the member of parliament can be disqualified. One is on the grounds of defection, which is mentioned in the 10th schedule of Indian Constitution. Another on holding a office of profit, as well as another ground on which a member of parliament can be disqualified is due to absence for more than 60 days without prior permission, and also due to the conviction by the court. So the Schedule 10 of the Indian Constitution, Article 101, 102 becomes very important with respect to the disqualification of member of parliament. That's all. So if you found this video informative, do like, share and subscribe. Thank you.